Tshiamo Sedumedi, who joins us to discuss the impact that all of this is going to have on a key sector of the South African population, domestic workers. Mr. Sedumedi, good evening, or good afternoon to you, and welcome. Now, my understanding is that many South African households would continue to pay their domestic workers during the lockdown, even though they are not working. I would suggest that ethically or morally this is the right thing to do. But what does the law say?
Good afternoon, Jeremy, to you and the viewers. As you correctly said, yes, indeed, ethically and morally, it is the right thing to do. I think it's part of the Tshiamo project that all of us are supposed to be complying with. But however, from a legal point of view, currently, the contract of employment that exists, in law, in contract law, we've got what we call a vis major. It means there's an impossibility of performance by either the employer and the employee. So strictly speaking, neither the employer nor the employee can enforce the provisions of the employment contract. However, like you correctly said, it will be out of good heart and part of the Tshiamo project to ensure that despite the fact that parties are unable to perform in terms of the contract, they still continue to pay their employees, in particular, the domestic workers.
So if that contract then were to be enforced, legally, are you saying that the domestic worker who would then be without income has no recourse?
Correct, which is why, in actual fact, the government, in particular the Minister of Employment and Labour, has passed a directive on the 25th of March, specifically to contemplate such type of a situation where they've created a special scheme under the auspices of the UIF to ensure that those employees who are not able to be paid because of the COVID-19, they are able to rely on the scheme under the UIF to claim, like they would normally claim under the UIF. However, the snag is the same. As you can imagine, most of our domestic workers are not registered in terms of the UIF. So only those persons who are UIF contributors can be able to claim under the specific scheme.
And part of that is that employers, I understand, have failed to complete something called the UI-19 form, or even pay UIF contributions. If employers have failed to fill in that form, are they then in breach of the law, and what could happen to them? Correct.
Any person who has not been listed as part of the UIF, unfortunately, won't be able to claim under the scheme, because it specifically says only a contributor can claim under the scheme. So those employers who unfortunately have failed to register their domestic workers for UIF will not be able to claim under this particular scheme. And obviously, the normal course of consequences that flow from that will arise against those employers. And as you can imagine, most of our domestic workers are not actually UIF registered, and that's exactly because of the problems by the employers, not the domestic workers themselves.
But now let's assume that the domestic worker is registered with the UIF. One of the other problems that's being raised by experts, I imagine yourself included, would be the system itself is not going to be able to cope with what would appear to be a flood of applications.
Correct. I mean, look, one can only hope, because see, this scheme is a separate scheme set up specifically for COVID-19. So one will hope that the powers that be will ensure the systems runs as efficiently as possible to ensure, because the whole idea is to provide relief to those employees who are not able to claim, to get paid their salaries during this period. So one can only assume that government will come to the party and ensure that all the systems are working efficiently to provide the much needed relief to such days to the employees.
There's one other and one final strand that I want to explore with you. There are reports of people who terminated the service of their workers ahead of the lockdown in expectation of what was going to happen. Would they then have acted unlawfully?
Look, yes, obviously the normal course of the law will all apply in that instance. Obviously, I'm assuming that will only happen post the lockdown. Any unfair termination of employment, our laws are quite clear on that issue. I think the CCMAs of this world are there to cater for such situations. But unfortunately, that will be a very, very unfortunate turn of events. Because, I mean, if you recall, the President has actually asked us, all of us, to put our shoulders behind the wheel and ensure that we keep the situation as normal as possible under the circumstances. So, yes, indeed, those who have, in anticipation of this disaster, unfairly terminate the employees' contracts, yes, they will face the full might of the law in terms of our applicable labor laws.
It's all about maintaining, one hopes, a moral and an ethical compass during these very difficult times. Tshiamo Sedumedi, thank you very much for joining us. He's the managing director of the law firm from MNS Attorneys, on the line to us via Skype.